Namaskar. Welcome to my channel Journey of Constitution of India. There is a phrase Catch 22 situation. In fact, Catch 22 is a novel written by Joseph Heller in 1961, and this phrase has its origin from there. Catch 22 is a situation where no good solution is possible because solution problem is a part of the solution. और मुझे I remember one song in Hindi. पैसा कमाने के लिए भी पैसा चाहिए. Why I am saying it? Because this happened in the case of judgments on reservations. Some guidelines were given. To get that clarity, again one court was approached. Then again judgment was given. Then again court was approached for the larger bench. Why I am saying so? In Nagaraj's judgment, Nagaraj's case judgment, some guidelines was given. Then Supreme Court was approached for the larger bench to clear the cobweb of constitutional bench and cobweb of related to the reservation, and constitution bench was again in Jarnail Singh case was constituted. In 2018, this judgment on in Jarnail Singh first refused to refer the matter to the larger bench, and due to that judgment passed, the thing became more complicated and government again approached to Supreme Court. So in this background, in this backdrop, we are starting the today's journey. Friends, you are watching part 5 of Article 16, right to equality to opportunity in state employment. Hope you have watched the part 4 of Article 16. If not, please watch first that, so that you can have better understanding with the problems and with the facts and judgments we are discussing here. Let me say on personal note, if you watch this video as a video for information on reservation, it will not be much interesting for you. So what I would request you, that watch this video to know the constitution and constitutionalism in India, development of constitutionalism in India. In simple word, if you ask what is the constitution, then it is fundamental law of the land. Then what is constitutionalism? It is way of living with fundamental principles of constitution. And according to me, it is the constitutionalism is a journey of development of Trinity. Trinity means nation, its citizen, and the core values of the constitution in day-to-day social and political life. If you remember, Justice Kaparia, who dealt with the concept of constitutional personality in Nagaraj case, and the other concept of constitutional morality was dealt by Justice Deepak Misra in Navtej Singh Johar case. So if we are taking these concepts and in organic approach, then the constitutionalism develops. This is a very interesting topic, and I'll make a separate video on the development of constitutionalism in India. Our journey today reaches in 2018, and the case is Jarnail Singh versus Lakshmi Narayan Gupta, 2018-10 SCC 396. The case was heard by a constitution bench of 5 judges presided by Justice Deepak Misra, and the judgment was authored by Justice Rohinton Nariman. The court dealt with a batch of appeals, and the two references, one of 2 judges bench and the other of 3 judges bench, to see the correctness of the Supreme Court's judgment in M. Nagaraj's case of 2006. Hope you remember the Supreme Court in Nagaraj case upheld the constitutional amendment by which clause 4A and clause 4B was inserted in Article 16, that they flow, this 4A and 4B flow from Article 16(4), and there is no violation of any basic structure of the Constitution. This was also held that these are only enabling provision, and the state is not bound to make reservations for ST and SC in the matter of promotions. However, the situation became difficult when this bench provided, and this bench held that if the state wants to go for the reservation in the promotion, it has to collect quantifiable data showing backwardness of the class as well as inadequacy in the representation of that class in public employment, and it also held that the 50% ceiling has to be maintained. So, by this judgment, the court extended the concept of creamy layer principles to scheduled caste and scheduled tribe category too. Now, the Jarnail Singh judgment. The Jarnail Singh judgment, first, as I told you, the court, that bench refused to send the matter to the larger bench. However, it held that point of Nagaraj's judgment invalid, according to which the state had to collect the quantifiable data to show the backwardness of the class for which the reservations are to be provided in the promotion. It was declared invalid. However, it affirmed in Jarnail Singh case, the court affirmed that the concept of creamy layer and the principle of creamy layer is for excluding the affluent class in that society, that communities, is applicable to the scheduled caste, scheduled tribe, because this is a question. Here the court shifted its focus from interclass to intra-class, because the creamy layer is to be from the same class who has backed the benefits of the reservation, and now they have attained a certain level where it is better for the development of that class that they should be excluded, and those who have not availed should be given the opportunity to get the benefit of the reservation. So my friends, this being the case, it is clear that when a court applies the creamy layer principles in scheduled caste and scheduled tribe, it does not in any manner tinker with the presidential list of 341 or 342, because this is one of the argument given by the petitioners that implementing the concept of creamy layer in the STSC category is something like tinkering and something and disturbing, interfering with the presidential lead, but it is not the situation, because the benefit is going ultimately to the STSC category persons only, even if the creamy layer concept is implemented. However, now the situation is the center has moved to Supreme Court again with a prayer for referring the matter to the larger bench, because the 2018 judgment of Jarnail Singh somewhere is against the concept developed by Indira Sawhney's judgment in 1992, where the creamy layer concept was not applied to scheduled caste and scheduled tribe. I have informed in my previous video that government tried to clear the controversy by bringing 117 amendment bill. It passed in the Rajya Sabha, but it failed in the Lok Sabha. Since it has been passed in the Rajya Sabha, which is a permanent body, the bill is still alive. Because by this bill, the government wanted to make a dimming provision in favor of scheduled caste and scheduled tribe. They will be deemed to be backward. So the purpose and the idea of collecting data was to be avoided. The next judgment, which is the very latest judgment in this video, and for the purpose of reservation, is Mukesh Kumar and others versus State of Uttarakhand. This is decided on only 7th of February 2020. This is a division bench judgment and authored by Justice L. Nageswar Rao. In this judgment, the controversy pertains to the reservation in promotion of scheduled caste and scheduled tribe in Uttarakhand government. Two issues were before the court. First, whether the state government is bound to make reservations in public post, and second, whether the decision of state government not to provide reservations can be only on the basis of quantifiable data relating to adequacy of representation of persons belonging to STSC. This bench relied on the settled proposition of law, which has travelled a long way from Indira Sawhney's judgment to Nagaraj's judgment to Jarnail Singh judgment. So first it said that Articles 16(4) and 4(a) do not confer any fundamental right on any person to claim reservations in promotion. So this new thing came here that there is no fundamental right. It is only an enabling provision, and that wasted discretion in the state government to consider providing reservations if the circumstances so warrant. Second point, the settled principle was taken that the state government cannot be directed to provide reservations for appointment in public post, means no writ of mandamus can be issued against the state to implement and to provide reservation to any particular person. Similarly, the state is not bound to make reservations in STSC category for STSC category in promotions. However, it is said that if state government wish to exercise the discretion and make such provisions of reservation in promotion for STSC, then it has to collect quantifiable data showing inadequacy of representation of that state, that class in public service. So that if that is challenged, then state should come with the defense that they had collected the quantifiable data and their inadequate representation. Next, if the decision of state government is challenged, then state has to show two things. First, inadequate representation, and second, that there is no effect on general efficiency of administration as mandated by Article 335 of Constitution. Supreme Court in Janal Singh held that the state government is not bound to make reservations. This is a very clear case. And there was no fundamental right to the individual for providing reservations. No mandamus can be issued. So these are the settled principles on which this case was decided. So let us see now what happens. Whether an amendment or a decision from a large, in this situation, what can happen? So that's why I want to say either an amendment can be effected or a decision can be received from the larger bench to clear the situation which has arisen, and the government is in difficult condition, even because there are many cases where the posts are lying vacant and the government has to take steps in that case. So thank you very much for being with me in this journey. One thing is sure, the journey of constitutional development is to continue. Whether government goes for amendment or the larger bench comes with this any decision, but this journey will continue. Constitutional jurisprudence will be enriched. Thanks for watching this video, and please subscribe my channel. However, I am overwhelmed with the response I am getting from my friends, and they are helping me by sending their opinions and suggestions to me, and I'll be improving myself. Thank you very much. Please subscribe my channel. Namaskar.